let me start with the use of AI in courts. And I want to make a point here that there is a distinction between use in the courts from the perspective of the judges and how judges might or might not use AI, and I'll say a few words about that. But what I'm really talking about is the use of AI from the perspective of our users, people who come to the court for services. And I think that the areas where AI has proven itself so far to be the most competent and therefore the most valuable have been in things like summarization, in terms of things like translation, even in terms of things like document organization. And this has enabled us to zero in on those areas as potentially very beneficial for us to explore the use of AI in our systems. So I think most of you are familiar with the MOU that we have with Harvey AI. Harvey AI is one of the world's leading legal AI platforms. And we started talking to them, I think, very soon after ChatGPT. From memory, I think it was in April 2023 that I met the founder of Harvey AI. And by August, I think we had signed the MOU for them to come and work with us. And the object of that project is to enhance access to justice, which is one of the things we're going to talk about a little more in a few minutes. But the particular point that I was interested in was to explore how AI can help us make justice, in a sense, more accessible to lay users. And with that in mind, we focus specifically on the small claims tribunals. In that space, although the amounts, the ceiling of the amounts that are dealt with there is relatively low, it's about 40,000 at the moment. For most people in the small claims tribunals, when they're there, it makes a real difference. It makes a real difference to their lives. And if they have to incur a significant portion of that in legal costs, it's effectively a denial of access for them. That's why a deliberate choice was made for many of our tribunals to ensure that they are accessed by people, lay people, without the benefit of lawyers appearing. But this has a consequence because lay people are there, they don't have the awareness, their submissions may not be well organized, they may not be well presented. And Harvey was tasked to help us with this project, and we've been approaching it with them in a phase-by-phase basis. So the first phase, first two phases that we've worked with them on and that is already available to people are in translation of documents and in summarizing of documents. And so far, we have found that it has been extremely valuable and extremely useful in both these areas. The translation helps in a country like ours where people use different languages. I think it helps to get a quick, free translation. It may not be perfect, but it's good enough. Helps them understand some of the issues. But the summarization has been especially helpful in terms of taking the mass of documents and reducing it to a very manageable volume. And they can understand what the documents are. They can understand what the issues are. And it has even, our system at the moment even enables them to get a summary, not only of their own documents, summary of the other side's documents, and it also enables our tribunal magistrates to actually generate a summary with a list of issues that they need to look at. And we're continuing to work with Harvey. We would like to look ahead to the next couple of phases. For instance, we would like to develop the platform in such a way that users would be guided to load the relevant evidentiary documents at the right places. So sometimes if you have a claim for a breach of contract, you just put all the documents up. But imagine if the thing was structured in such a way that it prompted you, do you have a contract? Yes, please upload the contract here. Have you made a claim for under the contract? Yes, please upload your claim. You know, if it helped them to guide through the process to upload the documents in a systematic way, we think it would help them, and we think it would help the tribunal magistrates. That's one area that we're looking at. And another area that we're looking at down the road, subject to testing and subject to being satisfied that it can safely be deployed, is to enable the AI to actually summarize the case they want to make. So I think the AI can get there. I think it can get there to a way in which it can present the case that they wish to make and put that forward in a coherent way, which will actually help them. And if we could get to that stage, I think we've really used AI in a very productive way to enhance access to justice. I think there are several forces that have contributed to a question of sustainability. The first thing is, I think young graduates today have a very wide range of career choices. It's not the case that you're limited to practice in a law firm. We've got a very, very vibrant legal scene. There are many, many choices from Singapore law firms, overseas law firms, in-house counsel jobs, whole range of different opportunities, of course, the government service as well. So there's a very wide range of choices. The second factor, which I think has driven this, is the growing complexity of work. And it's a reality. And I can illustrate this with a very, very simple point that we can all understand. Just look at the volume of material that people have to deal with. If you think of the evidence in a typical case, today with emails and almost every single communication having some kind of a documentary trail, the volume of evidence that you see has just shot up. And you can similarly see that with the growth of legislation, the growth of regulations. You can see it in terms of the number of judgments that you have to deal with. At all these levels, you're seeing a growing complexity in the work that you have to do. And an additional factor that I think adds to this is something that I have referred to as something of a generation gap. And it's a particular phenomenon because we are in a workplace today where you have multiple generations in the same workplace. You've got people from the baby boom generation all the way to your generation Z or Z or whatever it is. I mean, there's a range of different groups of people, each of whom have slightly different perspectives, slightly different approaches to dealing with this. I think if we're not honest and candid and open in talking about this, we are going to overlook certain difficulties that can manifest. So part of what I've been trying to do is to encourage discussion and open conversation about these issues. So we started with a few of these surveys that I started taking from just around the COVID time. And each year when we have the mass call, we have a population of 400 or 500 people who are coming to do their admission. And it occurred to me at that time that it might be good to start getting some data in terms of what they're feeling. And the particular concern in COVID was, were they having difficulties securing training contracts? Because it was a time of great uncertainty, and I wanted to know whether they were having these issues. So we started with that. And over the last 4 or 5 years, we've been doing these surveys with the people who come for their call at the mass call. And we get very good responses. I mean, I think 70% or so of the people who come will give us a response. And the trend that consistently emerges points to a concern over sustainability. It doesn't prove anything because we're not talking about people who are saying, I've left the profession. We're talking about people at the very start of the profession and asking them about their attitudes, asking them about their anticipated approach and aspirations. And I think the answers they give us hints at a concern with sustainability because of the significant number who say that they anticipate leaving practice within 3 years, and a significant number who anticipate leaving the profession altogether within 3 or 5 years. And that by itself may not be a problem because in many jurisdictions people come to law and use their law degree for all sorts of different professions. But when we drill down to those who say they don't anticipate staying in the legal profession or they don't anticipate staying in the practice, and we ask them why, what's driving that, it's the answer they give us that suggests that there is a significant element of push factors that suggested that there may be a concern with sustainability. Because if we don't address those push factors, then we are going to potentially have a situation where there's a hollowing out of the profession. So that's the concern in which, that's the context in which I've raised it. I had a meeting a couple of weeks ago. One night we had a session with the young lawyers. I think the Young Lawyers Committee of the Law Society arranged a dialogue. I think about 100 of the young lawyers showed up, and I had a dialogue with them for a couple of hours, talking to them, trying to understand what's in their minds. And again, these are 100-odd lawyers of different levels, but mostly young people who are in the profession mainly. But it was very interesting to hear their perspective in a conversation, and they do feel that there are concerns that they need to, that we need to address. So I don't think it's an existential problem. I don't think that it is irreversible, but I think we need to be addressing it. And I have spoken to Minister Edwin Tong, and we have set up a number of platforms to address these issues. And he and I co-lead the sort of steering group to address this together with some judges. The PermSec of the Ministry of Law, some of his staff are involved, because we do think that it's important for us to address these issues. And I'm confident that we will address these issues, but we need to have very open conversations to understand what our young people are concerned about and to respond to them. I do think it is unhelpful for my generation, senior people, to brush this off as a problem of young people and say, oh, you grow up and get tough. I don't think that's helpful, because I think their conditions and their circumstances are different. And there are a number of different things that I think is impacting them, and we have to be very sensitive and alive to those realities. A few weeks ago, I listened to an interview on the New York Times of this former Senator Ben Sasse. One of the things he said about the problem was the fact that the common spaces have broken down. And he gave an illustration by reference to the fact that there was once upon a time you had 3 networks on TV, and everybody went and watched one of those 3 networks. And the next day when you talked about what you did the evening before, there's a good chance you both did the same thing. But he said as we went from 3 networks to 20 to 50 to 1,000, what you ended up doing was each person listened to the particular echo chamber that they wanted to listen to, and you had less and less common ground, and that created a lot of problems in society. So I think that's another very significant contributing factor to this breakdown of truth. The fact that there's a very real sense that there's no such thing as objective truth because people don't want to have truth dictated to them is another factor behind it. So all of these contribute to the problem of truth decay. And I think social media has contributed to it as well, because anyone now has access to mass media and mass reach. And it gives you the opportunity and the platform to pontificate on what you want to pontificate on and to propose the viewpoint that you think is true. Now, this has a huge challenge for courts because we are fundamentally truth-seeking institutions. That is our core work, not in the sense of metaphysical truth. I don't say that whatever we say is metaphysical truth, but it's truth based on the evidence. That's our business. Our business is to look at the evidence and to pronounce on what is true based on the evidence that has been led before us. And it's very important that people believe that, generally speaking, courts, when they issue judgments that are true based on the evidence that has been led. It's very important that people believe that. If you have a situation where most people believe, rightly or wrongly, if they believe that the courts are making their decisions in some other way other than based on trying to discern the truth from the evidence, you have a huge breakdown. breakdown of confidence in the courts, breakdown of order in society, in my view. So this ties into why we are so committed to making sure that we give reasons for our judgments, our decisions, why we give reasons for our decisions, and why we try to make sure that they are explained and accessible. I always make the point that you write judgments for a range of audiences. And it's not the case that you're writing judgments only to make law and only to speak to lawyers. That's one of the functions. But you're also writing judgments to speak to the parties. And more importantly, in a sense, you're writing judgments to speak to your country, to explain to them and to keep investing and building in this value of a trusted judiciary, where they can see for themselves why the court has reached a particular conclusion or a particular outcome. And I fully appreciate that doing that in a very long judgment may not be accessible to most people, which is why we have made it the norm to have these case summaries for most of the cases to enable people to access them. Those are the measures we're taking, and from the feedback loops that we have in place, they're still holding and they're still working, because we don't generally, I mean, we are still, Singapore is very blessed because we're still one of the few first world countries where, in fact, one of the few countries where trust in government and public institutions outranks trust in corporations. In many countries around the world, that has been reversed. So we're still blessed that people generally trust the public institutions that we have in place. And I think that that's a track record that we have to work really hard to preserve. It is a real issue and we have to work at it.